Good day, dear listeners. It's Lena again, and I'm so glad you're here with me today. Before we begin, please take a moment to subscribe to the channel and tap the like button. It helps these stories reach the people who need them. And tell me in the comments which city you're listening from. I love seeing just how far these stories travel. My brother said I had no right to the land. The county record showed a 20-foot easement running straight through his subdivision plan. My name was on it. It had been there since our grandmother recorded it. Stay with me. Because the line that stops a development isn't always a lawsuit or a fight. Sometimes it's a single line on a plat map, recorded 30 years ago, that nobody bothered to check. Property law is patient in a way that people are not. It does not forget. It does not revise. The document that your grandmother recorded at the county clerk's office before you were born is still there, indexed, stamped, binding, waiting for the moment someone draws a line through it. Helen Fierro did not know she was holding a boundary. She discovered it the same week her brother told her she had nothing. This is a story about a woman who grew up watching her grandmother record things carefully, and who did not understand, until middle age, exactly why. Helen Fierro is 45 years old, a licensed surveyor working for a civil engineering firm in Albuquerque, New Mexico. She has been a surveyor for 20 years. She came to it through the particular route of people who find a profession that suits both their character and their skills so exactly that the choice feels less like a decision than a recognition. Surveyors work at the intersection of physical landscape and legal record. They measure what is there and describe it in a form that the law can use. They produce the plat maps, the boundary descriptions, the recorded instruments that give legal meaning to the physical fact of where one piece of land ends and another begins. It is precise work, methodical work that requires both the patience to be accurate and the understanding that accuracy matters because people's rights depend on it. Helen grew up in Albuquerque's South Valley neighborhood, on her grandmother Rosa's land. Rosa Fierro had acquired 2 adjacent parcels in the 1970s, the larger one facing the street, the smaller one a narrow strip along the western edge with a different character and a different view. Less accessible, more private, with an afternoon light that came in low from the Sandia Mountains in the east, and gave the western edge a particular quality that Helen has never adequately described to people who have not seen it. The light and the view, those 2 things. She has never been able to justify selling the strip, and she has never been able to explain why, except by pointing toward the mountains at 4 in the afternoon when the light is what it is. Rosa had been meticulous with the land. She had documented it, improved it, paid the taxes on it. And when she began thinking about her eventual death, she had recorded a subdivision plat in 1988 that divided the 2 parcels formally for estate planning purposes. She had hired a surveyor, the profession that would become Helen's, to prepare the plat, and had overseen the filing personally at the Bernalillo County Recorder's Office. She had understood, in the way of certain women of her generation who had held property carefully through decades of economic uncertainty, that the record was the thing. The record was what persisted. The record was what prevented the informal from becoming the official. She had also written a note, handwritten in Spanish, folded inside the plat. The note said, in her careful schoolteacher's print, the easement on the western edge of the large parcel protects Helen's access and should never be given away without her agreement. Helen's grandmother had thought about Helen specifically. She had thought about her before Helen was old enough to understand property law, before Helen had become a surveyor. Before anyone knew that the land adjacent to the South Valley parcel would one day be the subject of a subdivision plan and a development permit and a property court hearing. She had simply thought about her granddaughter and written her name in a note and folded the note inside a plat map and recorded it all with the Bernalillo County Recorder's Office, where it waited for 30 years. Rosa died 11 years ago. Her estate was divided, the larger parcel to Carlos, the smaller to Helen. Helen had rented the strip to a neighbor since, a small monthly income that she had used for the land's property taxes and maintenance. She had held the land without developing it, in the specific way that people hold things they are not ready to decide about. The view. The light. The particular quality of a place she had grown up near, and that felt, in a way she had not found words for, like her grandmother's presence in a form that did not require words. Carlos Fierro is 50 years old, a real estate developer in Albuquerque who has been building residential properties in the region for 20 years. He is confident in the way of people who have been successful in a competitive field and who have developed, from that success, a belief that they understand the landscape better than most. He had planned the subdivision for the larger parcel carefully, 20 units, a well-designed entry, utility connections from the public road on the western boundary. He had engaged his attorney, his engineer, his contractor. He had filed for the preliminary permits. He had told Helen about the project at a family dinner in the way you tell a family member about a project when you have already decided what you are doing and you are informing rather than consulting. He said she should think about selling her strip while there was still interest, because it was a sliver, and it was worth nothing without access. Helen went home and pulled the Bernalillo County parcel records. She is a surveyor. She pulls parcel records the way other people pull out their phones to look something up, by instinct, as a first response to a property question. Because parcel records are the kind of thing she has been reading since she was 23 years old, and they tell her what she needs to know faster than anything else. She had not pulled the records for her own parcel recently. She had inherited it. She knew it. She had rented it without thinking there was anything to look at. But Carlos's comment sat with her on the drive home in a specific way. A sliver. Worth nothing without access. She wanted to know what the record said about the access. She sat at her kitchen table that evening with the county records on her laptop. She found the original subdivision plat that Rosa had recorded in 1988. She opened it. She looked at the plat the way a surveyor looks at a plat, methodically, checking the boundary descriptions, the reference points, the recorded instruments. She saw the easement notation on the western edge of the larger parcel, a 20-foot corridor running north-south the full length of the boundary, labeled utility and access easement, benefiting the smaller parcel. She read the notation twice. She looked at the coordinates. She looked at Carlos's subdivision plan, which had been filed with the county as part of the permit application. She pulled it up. She looked at where the utility connections were routed. The 20-foot easement corridor ran directly through the route Carlos had planned for his utility connections. His subdivision required water and sewer connections from the public road on the western boundary. The western boundary was adjacent to Helen's strip. The easement ran through exactly the portion of his parcel where the utility trenching would need to occur. To install the utilities as planned, the construction would cross the easement corridor. To cross the easement corridor, he needed her consent. She had not been asked. She called Carlos the next morning. He was on another call and called back in the afternoon. She said, "I pulled the parcel records for both properties. There's a recorded 20-foot easement on your western boundary that I haven't seen before." Carlos was quiet for a moment. Then, he said, "Grandma didn't know what she was doing with all that paperwork. That easement was never meant to be permanent. She said, "It's recorded." He said, "It's 30 years old. Nobody enforces 30-year easements on family land." She said, "I'm not nobody." He said, "Helen, don't be difficult about this." She said, "Good night, Carlos." She ended the call. She drove to her office the next morning and sat at her drafting table with the recorded plat spread out in front of her. She called Yolanda Birch. Yolanda Birch is 49 years old and has been practicing property and easement law in Albuquerque for 21 years. She is the kind of property attorney who can read a plat the way Helen can read a plat, methodically, with a professional's understanding of what recorded instruments mean and how they function and what the legal consequences of their existence are. When Helen described what she had found, Yolanda asked her to send the plat. She reviewed it that afternoon. She called Helen back with the same directness that good property attorneys use when the legal position is clear, and explaining it simply is better than hedging. This is a valid appurtenant easement. It was created expressly, recorded with the county. And it binds all subsequent owners of the servient estate, Carlos's parcel, without expiration. 30-year-old recorded easements do not expire. Carlos cannot construct utilities across this corridor without your written consent. Helen said, "His permit is already in process." Yolanda said, "His permit will be placed on hold when the county examines the title history. The easement is in the record." "It will come up." Helen said, "He doesn't know it's there." Yolanda said, "He should have checked." Helen said, "He's a developer. He should have done the title work before he filed." Yolanda said, "Yes, he should have." The Bernalillo County Development Review Office placed Carlos's subdivision permits on administrative hold 10 days later. A hold triggered by the title examination that is standard in the permit review process, during which a county examiner reviewed the parcel history and identified the recorded easement. Carlos received the hold notice from the county before he heard about it from Helen. He called her that evening. She did not answer. She had nothing to add to what she had already said. Carlos's attorney filed a motion to have the easement declared abandoned or extinguished through non-use. The argument was that Rosa's easement had been recorded in 1988 and had never been exercised. There had been no formal utility construction in the easement corridor, no documented access, no evidence of use, and that this non-use over 30 years constituted effective abandonment. Yolanda's response was grounded in New Mexico property law. The state requires clear and convincing evidence of intent to abandon an appurtenant easement, and non-use alone, however extended, is insufficient to meet that standard. The easement holder must demonstrate affirmative intent to abandon, not merely passive non-use. Helen had not expressly abandoned the easement. She had not been aware of it. Her lack of awareness was not an act of abandonment. Yolanda also produced Rosa's handwritten note. The note had been folded inside the plat for 30 years, in Spanish, in Rosa's careful schoolteacher's print. Translated into English for the court record, it read, "The easement on the western edge of the large parcel protects Helen's access and should never be given away without her agreement." Rosa had not recorded the note as a legal instrument. It was not a recorded document itself, only a document found inside a recorded document, but its existence was relevant to the question of intent. Rosa had intended the easement to protect Helen's access. She had written this down. She had folded the note inside the plat she filed with the county. The note was still there when Yolanda unfolded the plat 30 years later. Carlos's permits remained on hold through the fall and into winter. The property court hearing was scheduled for January. Let me tell you about the hearing. because it had a moment that I want to describe precisely. Carlos was on the stand. His attorney had just presented the revised subdivision plan, the alternative routing that avoided the easement corridor, at an additional construction cost of $340,000 as evidence of good faith. This was a legitimate legal strategy, demonstrating willingness to accommodate the easement holder in order to argue that the dispute should be resolved without litigation. The revised plan was real. The $340,000 was real. Carlos had instructed his engineer to prepare it. Yolanda noted, in response, that the revised plan still required crossing a secondary portion of Helen's strip parcel for a different utility connection, a crossing that Carlos had not discussed with Helen either. The judge asked, simply, "Did you ask her?" Carlos said, "She's my sister." The judge repeated the question, with the specific patience of judges who have decided to require a direct answer. "Did you ask her?" Carlos looked at the table. He had not asked. He had assumed. He had spent his professional life as a developer who asks about permits and engineering and construction costs, who negotiates with utilities and municipalities and contractors, who plans the physical and regulatory path of a development with professional care. He had not asked his sister whether her property rights would permit the project to proceed. He had assumed she would cooperate. She was family. The land was family land. The easement was an old thing that his grandmother had filed without thinking clearly about its implications. She would not make this difficult. She was not making it difficult. She was reading a plat map. She was doing her job. The judge ordered mediation. Helen was in the second row of the courtroom. She had brought the plat map, the large folded kind, printed on tracing paper, the county recorder's stamp on the corner. She had not unfolded it in court. She had held it in her lap through the proceeding. In the manila envelope she kept it in the same way she carries plats to fieldwork, covered, protected, available when needed. She had not needed to produce it. Yolanda had the certified copy in evidence. The original was in Helen's lap because she had wanted it near her. She did not look at Carlos during the hearing. She did not look at the table where his attorney was arguing about good faith and the cost of the reroute. She looked at the front of the courtroom with the measured attentiveness of a professional who is monitoring a proceeding and has nothing she needs to demonstrate. The mediation was scheduled for 3 weeks later. It produced the outcome that Yolanda had indicated was likely from the beginning, a negotiated arrangement that allowed the development to proceed while acknowledging Helen's legal position. The terms were the terms of a real negotiation, not a formality. Carlos paid $127,000 for a limited, revocable construction license. The right to cross the easement corridor for the specific utility construction, with defined dimensions and timeline, revocable if the maintenance obligations were not met. He also accepted a permanent maintenance obligation on his side of the boundary, which meant that the western edge of his subdivision would be maintained at his expense as long as the development stood. Helen's strip gained a value it had not formally had before, a documented, legally binding, maintained boundary condition that the $127,000 confirmed in monetary terms. The subdivision proceeded. Helen kept the strip. She did not sell it. She will not sell it. She hired a landscape architect in the spring and began planning a small courtyard garden on the western edge of the parcel, the edge with the view of the Sandia Mountains, with the particular quality of afternoon light that has always been there and that she has never been able to justify surrendering. She is planting desert plants, native grasses, chamisa, a single large agave that she has been tending for 2 years in a container until the garden is ready. She intends to sit in the courtyard in the late afternoons when the light is what it is, and the mountains are the mountains, and the land is her land, held in a document her grandmother filed 30 years ago. Rosa's plat map is framed now. It hangs in Helen's office, beside the drafting table where she reads plat maps for a living. The fold lines are visible through the glass. The county recorder's stamp is in the lower right corner. The easement line is there, the 20-foot corridor along the western edge, the notation that had sat in the Bernalillo County records for 3 decades, waiting for someone to build a subdivision plan through it. Helen's grandmother had thought about this. She had thought about Helen specifically. She had written her name in a note and folded it inside the map. She had not been able to tell Helen why she did this. She had died 11 years ago, before Helen knew enough to ask. But the note said what it said. The easement protects Helen's access and should never be given away without her agreement. Rosa had known that someday someone would want to give it away. She had made it Helen's agreement to give. I want to tell you something about what it means to be a surveyor who finds her grandmother's work in a county record. Helen has described this as one of the stranger professional experiences of her life. Not strange in a negative sense, but strange in the way of experiences that collapse the distance between the professional and the personal in a way you do not anticipate. She reads plats every week. She reads county records every week. She understands at a professional level that the records she reads were made by people, surveyors, attorneys, landowners, clerks, who were doing their jobs and creating instruments that persist in the county's database long after those people are gone. She had not thought about her grandmother as one of those people. She had not thought about Rosa as a client in a surveyor's office in 1988, sitting across from someone like Helen, reviewing the plat that the surveyor had prepared, signing the documents, arranging the filing. She had known Rosa as her grandmother, as the person who had kept the land and kept the household, and taught her the Spanish words for things that had no English equivalent, and made her sit at the kitchen table and do her homework before anything else. She had not known Rosa as the client who had hired a surveyor to prepare a subdivision plat and who had asked the surveyor to include a 20-foot easement benefiting the smaller parcel, and who had told the surveyor, "This needs to be recorded. It needs to be in the record. It needs to say specifically that this parcel's access is protected." She knows this now. She knew it when she unfolded the plat and found the note. She knows it when she looks at the framed plat map on her office wall and reads the fold lines and the stamp and the easement notation in the surveyor's precise print. Rosa had hired a surveyor. The surveyor had done the work. The county had recorded the plat. Helen had become a surveyor. Had entered the profession by a route that felt like recognition rather than choice. Had spent 20 years reading the records that people make in order to protect what matters to them, and 30 years after her grandmother sat in a surveyor's office and arranged for the protection, she had pulled the county records and found the line Rosa had drawn. The line is still there. It will be there as long as the land exists and the county maintains its records, which is to say indefinitely. A recorded appurtenant easement does not expire. It does not forget. It does not revise. It simply sits in the index, stamped and binding, and waits for the moment someone needs it. Carlos's development is well underway. Helen has seen the framing going up. She drives past the larger parcel sometimes, on her way to fieldwork in the South Valley area, and she sees the structures rising on the land that her grandmother also owned, and that her brother received at the estate division. She does not feel anything complicated about this. He is building what he planned to build. She is holding what she held. The boundary between them is the boundary Rosa drew. She thinks about Rosa sometimes when she is doing field work, when she is standing in an Albuquerque lot with her equipment, measuring and recording and producing the instruments that will govern that land's legal character for decades or longer. She thinks about the specific continuity of the work, that every plat she produces is a record someone will find someday in the county database, that every boundary she measures is a line that will persist in the document long after she has moved on to other work, that every recorded instrument she creates is a small act of protection for whoever holds the property interest it describes. She does her work with this in mind. She has always done it with care. She now does it with the additional knowledge of what careful work looks like from the other side, from the side of the person who opens a county database decades later and finds that someone measured carefully and recorded correctly and described precisely what was there, and that the precision is the protection. And the protection still holds. Felix Ortega, the senior examiner at the Bernalillo County Recorder's Office, called Helen 2 weeks after the mediation closed. He had been pulling historical plat records during the proceedings, standard procedure when a recorded easement is in dispute, and had found a second filing from 1992. Also Rosa's name, also on Carlos's parcel. The language was broader than the 1988 easement. It described access rights that neither Helen nor Carlos's attorneys had cited in the proceedings because neither had known it existed. Felix said, "I thought you should know before anyone else finds it." Helen said, "Send me the recording number." He sent it. She pulled the 1992 filing and read it at her drafting table with the professional attention of a licensed surveyor reading a document that affects land she holds an interest in. She read it twice. She photographed it. She forwarded it to Yolanda with the same message she had sent with the 1988 plat. "Look at this." She is not surprised. She is not alarmed. She is a surveyor. She reads records. She finds what the records say, and she acts on what she finds with the deliberate care that her grandmother demonstrated when she sat in a surveyor's office in 1988 and said, "This needs to be in the record. It needs to say the access is protected. It needs to have my granddaughter's name." She had not thought in 1988 that her granddaughter would grow up to be a surveyor. She had only thought about the land and the protection and the person who would need it someday. She had been right about the person and right about the need, and the record had held. It is still holding. There may be more to find. Helen will find it. She knows how. Rosa Fierro recorded that easement 30 years ago. She wrote the note by hand in case anyone forgot the reason. She was thinking about her granddaughter. The people who put things in writing for us do it because they know we'll need it someday, even if we don't know it yet. Know what your family recorded. Know what the county holds in your name. And if someone tells you that a piece of land is a sliver worth nothing without access, go pull the parcel records before you believe them. The line your grandmother drew may be exactly where they need to build. Thank you for listening today. Leave me your city in the comments. If this story made you think of a piece of land or a county record or a document that someone who loved you made for you, go find it. Like this episode if it stayed with you. I'll see you next time. Let me go back to the land itself, because the land is the character in this story that does not speak, but is present in every sentence. And describing it more completely is part of understanding what Helen was protecting. The South Valley is an older, quieter Albuquerque, as sequoia ditches, large lots, mature cottonwoods, houses in the same families for generations. Land there is not simply an investment. It is a history, a presence, inseparable from the people who have held it. Rosa Fierro had come to her land in this way. She had acquired the 2 parcels in the 1970s through a combination of savings, family inheritance, and the specific determination of a woman who understood that land in the Southwest. Was the form of security that persisted when other forms did not. She had held it through decades of fluctuating real estate values, through the growth of Albuquerque from a mid-sized city to a major metropolitan area, through the neighborhood changes that the South Valley experienced as development pressure from the north and east reached the older neighborhoods along the Rio Grande. She had held it through all of this without ever considering selling it. Because the land was not a financial instrument to her, it was the place where her family had its foundation. She had gardened it. She had kept chickens on the smaller strip for a period. She had rented the larger parcel to a neighbor for a few years when the children were young and the income was needed. She had paid the taxes every year, on time, in the specific way of people who understand that property tax delinquency is the pathway by which land leaves families who meant to hold it. She had held it. When she recorded the subdivision plat in 1988, she was thinking about the holding. She was thinking about what would happen after she was gone, about Carlos who would develop things, and about Helen who would hold things, and about the difference between those 2 natures and what each nature needed to be protected. Carlos would need the larger parcel and the freedom to build on it. Helen would need the smaller parcel and the access that gave it meaning. The easement was the instrument that protected the access, that ensured Carlos's development could not inadvertently or deliberately foreclose what the smaller parcel needed to function. Rosa had not used the word appurtenant in the note she folded inside the plat. She was not a lawyer. She was a school teacher who had hired a surveyor and understood the instrument at the level of its purpose. It keeps Helen's access open. It should not be given away without her agreement. She had said this in Spanish because Spanish was the language she thought in, the language of the land's history in the Southwest, the language of the legal documents that had governed property in New Mexico before New Mexico was a state. She had said it clearly and folded it inside the plat and filed the plat with the county and gone home. Helen has thought about that act, the filing, the deliberateness of it in the months since the mediation. She thinks about it in the way you think about someone's choices when you understand them retrospectively, when the choice has become visible in its consequence and you can see what the person was thinking even though they are no longer there to tell you. Rosa had known that the plat map would be filed and indexed and stamped and placed in the county database. She had known that the database would hold what she put in it. She had trusted the institutional memory of the county recorder's office to hold her intention for as long as the land existed. She had been right. The county recorder's office had held it for 30 years. Felix Ortega, who was not yet the senior examiner when Rosa filed the plat, he would have been a junior records clerk in 1988 perhaps, had found it in the database during the permit review. He had confirmed the recording date. He had confirmed the instrument was valid. He had not known whose grandmother had filed it or what she had been thinking when she did. He had known only that the record existed, and that the record governed the easement, and that the permit could not issue without resolution of the easement question. The county recorder's office held Rosa's intention for 30 years, without knowing it was holding it. Tens of thousands of indexed, stamped instruments that are functionally the legal memory of the land. Helen works with this database every week. She has always understood that the records govern what the land can and cannot do. She understood this abstractly. She understands it now in a different register. Someone who has found her grandmother in the database, read her grandmother's work in a 30-year-old plat notation. held the instrument that Rosa created as an act of care, directed specifically at her. The database is not abstract anymore. Helen was there. She received it. She is there every week, reading other people's grandmothers' filings, doing the same work they did, creating the same kind of records for people who will find them someday in the index and understand what the measurement was for. She does her work differently now. Not mechanically differently, her technique is the same, her precision is the same, her instruments are the same, but her understanding of the work's meaning has shifted in the specific way that practical experience shifts understanding, from knowing something abstractly to knowing it in the body, in the consequence, in the face of what the record actually does when someone needs it. She measures what is there. She describes it correctly. She records it in a form that persists. She does this knowing that the person who will need the record may not exist yet, or may be a child, or may be the grandchild of the person who hired her. She does this anyway, because the record is the thing that protects the land's truth against the revision that time and interested parties inevitably attempt. Her grandmother taught her this without instruction. She taught it by example, by filing the plat, by writing the note, by trusting the county to hold the record until the record was needed. The record held. Helen is the proof that it held. Let me tell you about Carlos in a way that goes beyond his role in the legal dispute. Because people in these stories are more than their mistakes, and Carlos is not simply a villain in Helen's story. He is a brother who made specific assumptions that a different kind of attention would have prevented. Carlos is 50 years old and has been building residential developments in the Albuquerque area for 20 years. He is good at his work in the ways that matter most practically. He finishes projects on schedule. He manages contractors with competence. He understands the permit process well enough to move through it without the delays that catch less experienced developers. He has built 32 residential projects in Bernalillo County. The South Valley subdivision was to be the 33rd. He had not done a formal title search before filing the subdivision plan. He knew the land, had inherited it, had paid the taxes, had had it appraised several times. His father had told him at the estate division that the title was clean. He had accepted this. He had filed the subdivision plan without the title examination that would have surfaced the 1988 easement before the permit application went in. This is the specific failure of assumption that Helen has thought about most carefully, because it is the failure that a professional in her field would never make. She would never advise a client to file a subdivision plan without a complete title examination. She would never accept a family member's assurance that the title was clean as a substitute for the county record. She would pull the record. She would read the record. She would describe what the record showed, regardless of what the family remembered. Carlos did not pull the record. He relied on memory, his father's memory, his own memory, the memory of a family that had held the land for decades and believed it knew what it held. Memory is not a record. Memory revises. Memory accommodates the version of the past that the present needs. The county record does not revise. The county record holds the 1988 plat with the easement notation exactly as it was filed, regardless of what anyone remembers or assumes. He has not apologized to Helen. She has not asked him to. They spoke briefly at a family event 3 months after the mediation, a birthday dinner for their mother, at which both were present, and at which neither mentioned the proceedings. Their mother had not fully understood what had happened, or had understood it, and chosen not to speak about it. Which is sometimes the same thing in families where land and money and inheritance have created tensions that predate the current generation. Helen and Carlos sat across the table and ate the same food and spoke about other things, their mother's health, a trip Carlos had been on, a book Helen was reading. The event proceeded. They drove home separately. She does not know what Carlos understood from the proceedings. She does not know whether he now checks the title before filing. She hopes he does. She has not said this to him. She has said it to colleagues. She mentioned the case once, in general terms, at a professional development session on easement identification and subdivision planning, and the colleagues had taken the point. She had said, always do the title search and read the recorded plat and look for easements from before the current owner's tenure. She had said, old easements are not dormant. They are simply waiting. She had been the person who received the lesson. She was now giving it. Let me tell you about the courtyard garden, because it is the ending of this story in the practical sense and deserves to be described. Helen hired the landscape architect, a woman named Esperanza, who specializes in native desert plantings, in the spring following the mediation. They walked the western edge of the strip together on a March morning when the light was already strong, and the air had the specific dry clarity of the Albuquerque high desert before the summer humidity arrives. They walked the boundary line that Rosa had measured and described in 1988. They discussed what could grow there, what would thrive in the afternoon sun, what would require irrigation, and what would be sustained by the acequia system that still runs through the South Valley. Esperanza proposed a low courtyard design, packed earth paths, native stone borders, plantings that would grow slowly over years to produce a complete garden rather than an instant one. She proposed the large agave as the centerpiece, already in its container, already 2 years into its growth, to be moved from Helen's house to the site. She proposed camisa, the yellow blooming desert shrub that is the signature plant of the Albuquerque autumn along the eastern border. She proposed native grasses and drought-tolerant perennials along the paths. She proposed a simple seating area on the western edge facing the Sandia Mountains, for the afternoons when the light is what it is. Helen approved everything. The work began in April. The agave was transplanted in May. By summer, the garden was planted if not yet established. The plantings were in the ground. The paths were laid, the seating area was in place. Helen drove to the strip on a Saturday in August and sat in the seating area and looked at the mountains. The light came in from the east at the specific angle that she had always associated with the strip, the angle that makes the western edge the best part of the parcel, at 4 in the afternoon. The garden was young. The plants were small. The agave was the only mature thing, and it sat in the center of the courtyard with the specific presence of a plant that has spent years growing into itself, and that will continue to grow for decades more. She thought about Rosa. She thought about the plat map on the wall in her office, with the fold lines and the county stamp and the easement notation in the surveyor's print. She thought about the note in Spanish, the school teacher's handwriting, the specific care of a woman who thought about her granddaughter and wrote her name down and filed the document and trusted the county to hold it. She thought, you were thinking about me. You drew a line on a map because you were thinking about me. I didn't know. I know now. She stayed in the seating area until the light changed and the mountains shifted from gold to purple in the way they do in the Albuquerque evening. She drove home. She made dinner. She called her mother and did not mention the garden or the easement or Carlos, because there are things that belong in the courtyard and not on the phone, and the garden was one of them. She will sit in the courtyard in many future Augusts. The plants will grow. The agave will take decades to bloom, which is the nature of agaves. And when it blooms, it will produce a stalk 30 feet tall and then die, having done what it was there to do. Helen intends to see this. She intends to be in the seating area, in the afternoon light. When the agave finishes the long work of its single bloom, she has time. The land is hers. The easement is recorded. The garden is planted. That is enough. I want to say something about Yolanda Birch's role in this case, because the way a good property attorney works in an easement dispute is part of the story's mechanics and deserves description. Yolanda had practiced easement law in New Mexico for 21 years. She had seen every category of easement dispute that the state's particular combination of Spanish land grant history, acequia water rights, reservation boundaries, and modern development pressure can produce, which is to say, she had seen a great deal. New Mexico property law is layered in a way that few other states match. The Spanish land grants that predate American statehood, the water rights that operate on their own legal system, the federal land allocations, and the private property development that has occurred on top of all of this. Easements in New Mexico often have histories that go back further than the record systems that were designed to hold them, and finding the relevant instrument requires the patience to search not just the current owner's title chain, but the full recorded history of a parcel. When Helen described the 1988 plat to her over the phone, Yolanda had asked for the recording number before anything else. She had pulled the instrument herself, read it herself, and identified the legal basis of the easement before calling Helen back with the analysis. This is how she works. She reads the document before she forms the opinion, because the document is always more specific than the summary and the specificity matters. The legal position was clear from the document. An appurtenant easement in New Mexico is created by an express instrument recorded with the county. It runs with the land, it transfers automatically with ownership of the benefiting parcel without requiring re-recording or reconfirmation. It cannot be extinguished by non-use alone. It requires either an express release from the easement holder or a court finding of abandonment based on clear and convincing evidence of affirmative intent. The easement holder must have done something that affirmatively showed they were giving up the right, not merely failed to exercise it. Helen had not abandoned the easement. She had not known she had it to abandon. Yolanda presented Rosa's note in the proceedings not as a dispositive legal instrument. It was not a recorded document and had no independent legal force, but as evidence of the intent with which the easement had been created, relevant to the abandonment argument. If Carlos's attorney was arguing that the easement had been intended as a temporary or informal family arrangement that had been constructively abandoned, Rosa's note said otherwise. It described a permanent protection for Helen's access, something that should never be given away without her agreement. The note was the easement creator's own statement of intent, written at the time of the easement's creation and preserved for 30 years. Its evidentiary weight was not technical legal authority. It was something simpler, proof that someone had meant what the document said. Yolanda has kept a copy of the case file, including the photograph of Rosa's note, in her office. She said once to Helen, in 21 years, "I have read a lot of recorded instruments. I have rarely found one with a note inside it. That was the most specific statement of intent I have encountered in an easement case." Helen said, she was a school teacher. She believed in writing things down. Yolanda said she should have been a property attorney. Helen thought about this afterward. Rosa had not been a property attorney. She had been a woman who understood the importance of the record, who understood it in the way that people understand things that matter to them practically, not in the abstract. She had hired the professionals she needed, the surveyor, the county recorder's clerk, and she had produced the instrument that would hold her intention in the database for 30 years. She had also, with the specific practicality of a school teacher who knows that the formal record may not be enough, written the note in plain language and tucked it inside. Just in case the record needed explanation. Just in case someone needed to know the reason. The reason was Helen. The reason was always Helen. Let me tell you something about what Helen does now in her professional work that she did not do before this case. She has always done accurate, thorough survey work, read recorded instruments, checked title history, produced plats she would be comfortable seeing filed and read by someone 30 years later. What she does now, additionally, is look for the note. Not literally, she is not finding actual notes tucked inside recorded plats, though Rosa's is not the only handwritten notation she has ever encountered in old county records. What she looks for is the intention behind the instrument, the reason a grantor recorded a particular restriction or easement or covenant, the specific concern they were addressing, the person or situation they were thinking about when they went to the county office and made the filing official. She has found that reading the instrument with this question in mind, why did someone record this, who were they thinking about, produces a more complete understanding of what the instrument means and how it should be interpreted. The intent is often in the language itself, if you read it with enough patience. Sometimes it is in the secondary records, the correspondence, the subdivision application, the title examination notes. Sometimes it is in the history of the parcel and the family that held it. Sometimes, if you are lucky, it is in a handwritten note in Spanish. Folded inside a plat that a school teacher filed in 1988 because she was thinking about her granddaughter. She reads more carefully now. She always read carefully. She reads with more awareness of who is behind the document, who made it, what they were trying to protect, who they were protecting it for. This awareness has not made her a different kind of surveyor. It has made her a better one. Felix Ortega deserves his own moment in this story, because he is the person who found the second easement, and his call to Helen is one of the story's quiet acts of professional care. He is 58 years old and has spent 32 years at the Bernalillo County Recorder's Office, long enough to have been there through the digitization of the historical records and to be. In the way of people who have spent decades in one institution, both its institutional memory and its institutional conscience, he knows where things are filed and where the gaps are. He had been the examiner assigned to the easement dispute that Yolanda's filing had created. In the course of pulling the historical plat records for both parcels, standard procedure in an easement dispute. Where the full history of the property needs to be available to the court, he had found the 1988 plat and confirmed it was correctly indexed. He had also found, in the manual records from the early 1990s, a period when some instruments were in the process of being transferred from paper to digital. A second filing from 1992. Also Rose's name. Also on the larger parcel. He had not been asked to look for this. He had found it because he is thorough, and because he understood that the full picture of the property's recorded history was relevant to the dispute. He had read the 1992 instrument and recognized that its language was broader than the 1988 easement, that it described access rights that extended beyond the specific utility corridor. He had recognized that this instrument had not been cited by either party in the proceedings. He had thought about what to do. He had called Helen directly. He had her number from the case correspondence. He had not called Yolanda first, or the court, or Carlos's attorney. He had called Helen because the instrument was in her name and she was the person who needed to know about it first. He had said, "I thought you should know before anyone else finds it. This is not a legally required act." Felix had no obligation to contact Helen about a record he discovered during a routine examination. He had done it because he is a professional who understands that the purpose of the county recorder's office is to protect the legal integrity of property rights, and that a property owner who does not know about a recorded instrument in their name cannot exercise the rights it describes. He had done it because Rosa had filed an instrument in 1992 that nobody had looked at, and the instrument might matter, and Helen was the person it was designed to protect. Helen has thought about Felix's call as one of the pieces of the story she is most grateful for, not the $127,000, though that is significant, and not the mediation outcome, though that preserved what mattered, but the call from the county examiner who found a second easement and picked up the phone and said, "I thought you should know." The 1992 filing is now in Yolanda's hands. Its meaning is still being assessed. It may expand Helen's rights significantly. It may require its own proceedings. It may resolve quietly once both parties understand what it says. Helen does not know yet. She is waiting for Yolanda's analysis. She is not anxious about this. She is a surveyor. She reads records. When the record says something she needs to know, she will know it. When it requires action, she will act. In the meantime, the courtyard is planted, the agave is growing, and the Sandia Mountains are the same mountains they have always been. Rosa recorded the easements because she knew her granddaughter would need them. Helen has found them both, the one she knew about and the one she didn't. She will find all of them eventually. That is what surveyors do. They find the lines that were drawn before they arrived, and they read them clearly, and they protect what those lines were meant to protect. She is her grandmother's granddaughter. She will do this well.